Perfect. So I'd just like to reiterate, please, can everyone put themselves on mute so that we've got no background noise? Perfect. So today we have 4 speakers. We have Ms. Rosie Turner, who has just qualified as a solicitor. We have Sir Nigel Priestley, MBE, who will be speaking first, and he's going to be talking to you about his life in the care and public department and what it's like representing those people in court. We have Melanie Hartley, who is a family solicitor and partner in the firm, and she's going to be speaking to you about what it's like to represent some of her family clients. And then we also have James Urquhart-Burton, who's going to be speaking to you about the litigation perspective. And James is also one of our solicitors and partners in the firm. So we're going to start with Nigel. So welcome, Nigel, and thanks for taking part today. So the first question that we've got for you is, what is it like representing someone in a care or public matter?
Well, as my colleagues will make clear, we live in very strange times at the moment. In case you're not sort of completely familiar with the work that we are doing, I am part of what we call the public law department, and we come in where the local authority are wanting to remove children or become involved in the life of children who are being cared for by the parents. And the local authority have to show that the parents have acted in such a way in terms of their parenting that either the children either have suffered or are likely to suffer significant harm. Very few parents actually want to lose their children, and of course we are in a situation now where we don't go to court unless it's a very particular type of hearing right at the end, a hybrid hearing where parents might come, but where everybody else is conducting the hearing remotely. Now, because I'm a solicitor, I have a big computer on my desk, I have a laptop at home, I have an iPad, and I have a smartphone. So I've got a full house. Many of my clients will not have a computer at home. Most will not have a laptop. A few might have some form of iPad. The majority may have a smartphone. So firstly, imagine yourself, you're about to potentially lose your children, and your only way of communicating is either down a telephone line or actually looking into a screen. When we used to go to court, clients would sit behind you if they had an important message to pass, to tell you, because they thought that the local authority were telling a load of porkies. They could tap you on the shoulder, they could pass you a note. It's really quite difficult to do that when you're on the phone, and therefore all of this requires a completely new set of skills. The upside is that we can do hearings in Norwich in the morning and Chester in the afternoon. The downside is that we don't see our clients on issues that that go right to the heart of family life.
Perfect, thanks, Nigel. And why do you go and represent your clients in court when you could just hire a barrister?
Of course, there are those who might just say that I just like the sound of my own voice. I think it's I think when you do the law, you either like paper or you like people, and if you like paper, you might become a conveyancer, a commercial lawyer, company lawyer, that sort of thing, whereby you like looking at making sure that when you buy a house, you're not buying it over a coal mine that's going to swallow it up. I like people, and if I can, I like to be able to tell their story to the court. And I think at times it's fair to say that court is theatre, and I could quite like a bit of theatre. But really, it's because really, when you've spoken to a client, you want to feel that that you can put over their story. Now, of course, we do use barristers, but there's been a big change, really, so that nowadays a lot of clients are represented by their solicitor rather than a barrister.
Perfect. And I'm not calling you old here, Nigel. I'm calling you experienced.
You can call me old.
Due to your many years' experience, do you still find it daunting going into court?
Absolutely. My colleagues again will may or may not tell their own stories. Sometimes you feel that you're only half an inch ahead of your clients in terms of what you know is or is not going to happen. There are, we can come before magistrates who are just ordinary people like us. They may not always act like that, but that's what they are. But then you could could be a district judge who's the next sort of tier up. Then after that, it could be a county court judge, a family court judge. Then after that, a high court judge. And let me tell you, high court judges have big brains, and sometimes before the other courts will set it out. But a high court judge might say, but Mr. Priestley, what about this? And it's at that moment that you go, well, there we are. Yes, good, very good question. Where you have to be quite, to use a phrase, light on your feet. So yeah, I mean, I'll tell you, I've got to leave this hearing. I've got to leave this because we've suddenly got an emergency hearing at 3 o'clock. Where we should have filed a statement. And I know the judge is going to be saying to me, Mr. Priestley, your statement was, so even in those moments, you want to get it right. And there are some judges who have the capacity to reduce you to a snivelling wreck.
Just to encourage everyone to go off in standing court. And what is your worst experience in court?
Oh, I've got several of those. So there I was, a young solicitor, and I started going out with this girl who became my wife eventually. And we were going to Sheffield, and I got a hearing in the coroner's court. I worked for a posh firm at that point, and I went in, and it was a sad story of somebody who died in a car crash. And this firm were funded by clients funded by an insurance company, and so there was so and so, and then so and so spoke, and then I got this very clever question worked out, and and stood up, and the coroner said to me, Mr. Priestley, yes, I see you here for so and so. I don't think you've got any locus, have you? And at that moment, for those who are not lawyers, locus means locus standi, and it means you've got the right or not to speak, to actually, you can be there and take notes, but actually to speak and ask questions. And the reality was, I didn't have any locus standi. And so there I was seeking to impress Sue, and I had to sit down as quickly as I had stood up. So was that my worst experience? Well, it certainly ranks as fairly difficult.
Perfect. And just a final question for you then. How do you deal with those difficult clients?
Well, we deal with a whole spectrum of people. But I remember there are the occasional eccentrics, and people feel very strongly, obviously, about the loss of their child. So I was representing this woman in Stoke, and her child had been removed from her care, and she was wanting to claim the child, get the child back. And the child was called Phoenix. So she came to court dressed as a phoenix, and she got a bag out, and she put photographs of her child in a line facing the judge, dressed as a phoenix. Well, that was my first experience of representing a phoenix, I'm bound to say. And she didn't improve. In the end, she found out where the district judge lived and sent threatening messages, and she was barred from the case. But so what is it? Well, it's it is learning that actually there are some really interesting people in this world, and through experience, you can get sufficiently hardened to know how to deal with them. But only we're representing a woman who's an alcoholic at the moment in care proceedings, and we had a hearing about 3 weeks ago. One of my colleagues went for me, and she persisted in, and of course, because we can't take her out of the court because she's just she persisted in shouting at the judge, down her telephone line until the judge muted her. So there are some situations which do go beyond control, but by and large, it's all part of the learning, great learning curve.
Perfect. Well, thank you very much, Nigel.
I'm sorry I'm going to leave you. Otherwise, it'll be toasted Priestley by the judge in Wolverhampton.
That's absolutely fine, Nigel. Thank you again.
Cheers.
Perfect. So if anyone has any questions for Nigel, then please don't hesitate to put them in the chat, or you can pass them to Rabina or any one of your teachers, and they'll be able to pass it on to me, and I'll be able to ask him for you. So the next speaker is Rosie Turner. So Rosie also works in our care and public department, and she has just qualified as a solicitor. So she's going to be speaking to you about her kind of like first time experiences in court. So Rosie, if you could take yourself off mute.
Yeah, hello everyone.
Hi Rosie. So thanks for being here with us today. And the first question I've got for you is, what is it like stepping on in front of a judge for the first time?
So initially, probably more so before actually going into court, and the whole build up to going to court, it is really scary. There's no doubt about it. It is nerve wracking, and I think that, to be honest, it would be strange if you weren't nervous, because being in a courtroom, it's an extremely intimidating environment, and on top of being out of your comfort zone, you're there to do a very important job. So it's completely natural to feel nervous, and I think that's expected, and the judge understands that. But for me, and I think that probably most advocates would agree, preparation is absolute key. So as long as you're going into court prepared, and you've spent time going through your case, familiarising yourself with your client's case, and you're confident in what their position is on the key issues before the court, actually being before the judge, then it's not that scary. It's more the build up and the pressure, and thinking about how potentially awful it's going to be. That's the worst bit. And it's like anything, usually the thought of doing something is so much worse than the actual reality of doing it. So I think that the best piece of advice that I can give in order to try and help manage that court anxiety is to just be as prepared as you possibly can, and that's down to you to do. You can easily do that. You've just got to spend time doing it. And in my opinion, the best way to prepare is to sort of try and preempt any questions that you think you might get asked by the judge. And I think in order to do that, what you need to do is think about what the key issues are in the case. What needs to be addressed, what matters are still outstanding, and what needs to be resolved. And you've just got to make sure that you know your client's position in relation to those outstanding issues. And it really is that simple, because it's your job as an advocate, obviously, to advise your client about what you consider to be in their best interest, but it's also to make sure that they've got a voice in court, and just make sure that you're that person putting their views across to the court. So as long as you know what your client's views are, then I don't think you can really go that far wrong. And I think as well, another tip that I found helpful is, when you do go into practice, do try to absorb everything that you possibly can from the advocates around you that you work with. So for me, that's Nigel. Like, I've learned a lot from Nigel and his many, many years of experience. So I think that, before I went into court, I asked all my colleagues for advice and for tips, and I'd ask them if I could sit in on court hearings with them. So, you know, pre-COVID, I'd actually go to the court building and, you know, sit behind and listen to everything. And now that it's all being done remotely, it's actually much easier because I can just sit in the room very quietly and listen to what's going on, and just basically just, you know, listen to how the clients, you know, how you speak to your client and how the other parties converse with each other and how you address the judge and things like that. It's just good to absorb all of that, and you feel much more confident than walking into a courtroom. But I have to say, you know, the court experiences that I have had so far, you know, have all been absolutely fine, and I've been terrified before every single one of them. But, you know, as long as you know the case inside out and you've got confidence in yourself, like I say, I really don't think you can go far wrong.
Perfect. I know that a few court cases that I've sat behind, the judge has been a bit of a terror, shall we say. So that could obviously put people off. But like you said, as long as you're prepared, then that's the main thing. So the next question we've got for you is, have you ever been able to overcome those nerves in the build-up of it?
So like Nigel said, I mean, even he still gets nervous now. And I'd love to be able to sit here and say that I don't get nervous going into court, or I don't get nervous thinking about going to court, because, you know, that wouldn't be true. I do get nervous. And, you know, like I say, experienced lawyers and barristers, even they get nervous before going into court. And it's for a variety of reasons, really. So it might be just that you feel completely out of your comfort zone and you're scared of public speaking and things like that. You know, it might be that you've got a particularly complex case that you're worried about, or it might be that, you know, you've got quite a demanding client, like you said before, and they've got quite high expectations of you. Or like you said as well, it might even be that you're scared of going for the particular judge that you're supposed to be, that's supposed to be hearing the case, because there are some judges that are really scary and they're known for it. And, you know, you've just got to think, like, they are just a human being at the end of the day, and they're probably really nice in normal everyday situations, but, you know, they're there to do a serious job and make important decisions. So, you know, there are some judges that are a bit scary, that makes you a little bit anxious. But, you know, it's just human nature to be nervous about things like that. And actually, I remember there's a lady who was supposed to be here today, but she couldn't make it. She's a very experienced lawyer, and she used to be a barrister. And I remember I was speaking to her before my first court hearing. She really helped me through it. And I said, you know, I just can't wait for the day to go into court and just not be nervous. And she was like, well, that day is never going to come. She said, it's almost just like getting used to that feeling of being nervous. And, you know, you just got to, with anything, it's practice. Practice always makes perfect. And if you do something that scares you enough times, you know, the next time you do it, you might still be scared, but you've done it before, so you know you're going to come out on the other end okay, and you're going to survive it. And, you know, there might be some hearings that you come out of and think, oh, that went really well, and be like really chuffed. But there might be times where you come out of a hearing and say, you know, well, that's not quite the outcome that I wanted, but you've just got to learn from your previous experiences and pick yourself up and move on to the next one.
Perfect. And just finally then, so did you feel that there was a lot of pressure when you were going in to do your first case especially?
Yeah, there is a lot of pressure, and I think it comes in a variety of different forms. So, you know, first of all, you feel pressure not to feel like you're looking silly in front of the judge or the other advocates or even your client, you know, if you don't know the answer to something. Or you might feel pressure from your client because you don't want to let them down. And then there's personal pressures as well that come from within that you put on yourself, in that, you know, you just want to do a good job and you want to perfect your skills and be a really effective advocate. So, you know, there is that pressure. But like I said before, you've just got to try and manage that pressure. And the best way to do that is to be prepared. Because if you know what's coming, you can then take steps. It's in your power to deal with it. You know, information is power. And the more that you can inform yourself about a particular issue or situation, the better you'll be able to speak on behalf of your client, and the more confident as well that, you know, you'll feel in doing it. And, you know, if you can demonstrate to the judge that you have a good understanding of the case, the judge will usually take a particular liking to you, because they then have confidence in you and they know they can rely on you to tell them what they need to know.
Perfect. Well, thank you, Rosie. If anyone has any questions for Rosie, you can direct message me in the chat, or I know pass it to Rabina, and we can ask Rosie at the end. So thank you again. So our next speaker is family solicitor and partner at Ridley Hall, Melanie Hartley. Now, Mel's going to be talking to you about her experience in the family department and what it's like with her going into court. So, Mel, if you could unmute yourself.
Hello.
Hi. So thanks for joining us today. And the first question we've got for you is, what areas of family law require you to go to court?
Okay, well, that's an easy one. Literally every area of family law requires to court. You can have a dispute in family over anything. And I mean, the way in which we deal with it is court is a last and final resort. So you try loads of other methods to try and deal with a situation before resorting to court. You try mediation, sometimes arbitration. We get involved in correspondence with solicitors and the other party. So we only go to court if it's absolutely necessary, but literally everything could result in court. The main things that I'm in court for is divorce financial settlements, when parties can't reach an agreement, and also disputes over children. But there's also an abuse element that we can often see ourselves in court over as well, which is non orders and occupation orders where somebody needs to occupy a property. So yeah, pretty much my job involves a lot of court work.
Perfect. And what is it like representing someone in a family case?
Well, I think it's already been touched on by Nigel and by Rosie. Literally, you really don't know what to expect because clients are different. As people, we're all different as individuals. We all have a different level of understanding of issues. We're just different in our nature. And in that respect, it can mean that you can come across a certain number of issues and different personalities in court. So there are no two cases that are the same. So you have to be prepared for every eventuality, really. That's what makes this area of law really interesting, because you literally deal with different things on a daily basis. Even every hour, you come across a different issue, and it does make the variety is good and it's interesting.
Perfect. So the final question we've got for you is, do you go to court often?
Yes, I think I've probably touched on that. It's pretty much on a weekly basis. I could be in court a couple of times a day on some days. Weekly, I usually find myself in court at least once. I mean, don't get me wrong, there's some days where you look at your diary on a Monday and think, right, there's no court hearings this week. I can really knuckle down and do a lot of my casework. But then emergency situations can happen. And that's the nature of family work as well. You know, somebody could be in an abusive situation and require immediate assistance. And in that case, you then have to drop everything. Everything that you'd planned to do that day has to go out of the window because you need to help someone on an urgent basis. So it can be really, really fast paced. But again, you know, it's the nature of family law. If you like things being fast paced and interesting and no 2 days being the same, then family law is definitely something to consider. If you like talking to people, if you like going into court, or the thought of going into court, irrespective of what everyone said about it being nerve-wracking, it is. I completely agree with what Rosie said. There is nobody who I've ever come across that has said, I don't get nervous. I've spoken to very, very experienced solicitors and partners and barristers, and it's that nervous energy that drives you through. And at the end of the court hearing, you're on a massive high, even if it's not necessarily gone as well as what you wanted it to go. You've achieved something for your client, you've seen a process through, and they just feel really, really relieved. So it's definitely, you have to be suited to that as a person, and getting some experience in working in a law firm as well can obviously help you find out whether that does suit your personality or not. But yeah, it's very varied.
Perfect. Thanks, Mel. I'm just going to say, Mel's taken over our Facebook and Instagram accounts today, and she's kind of giving tips on family law and what it might like to be a solicitor. So if anyone has any further questions for Mel that's primarily based in family law, just drop her a message on either our Instagram or our Facebook, which is at just Ridley and Hall Solicitors. So thanks for that, Mel. And if anyone has any specific questions to the advocacy, obviously you can drop me a message or ask Rabina, and we'll be able to come to it at the Q&A at the end. So our next speaker is James, who is in our litigation department. He is a partner in the law firm. So he's going to be talking to us about kind of what litigation goes to court and kind of what you look for when hiring barristers. So James, if you could unmute yourself, please.
Hi, Natalie, you okay?
I'm not bad, thank you. How are you?
Good, thank you.
Good. So the first question we've got for you, James, is what areas of litigation require you to go to court?
Oh gosh, that that could be answered subjectively in a couple of sentences, or I could talk for half a day about it. I'll probably try and fall somewhere in the middle, maybe not quite in the middle. Well, I suppose the question is, what do we mean by litigation? Well, really broad term, but generally the process of making or an application to court or defending. And really, I suppose the straight answer to that is any legal dispute that isn't capable of resolution has the potential to end up litigated. And I don't know whether, similarities to what Melanie was talking about, whether she would call her line of work litigation, I don't know, but all, potential dispute areas. The areas of law that I deal with that do often end up in court are inheritance disputes, claims about validity of wills or invalidity of wills, Inheritance Act claims, but all manner of other things, contract disputes, the works, you name it. And I suppose also for those students who might go on to do their legal practice courses and further postgraduate training, I remember that they'll distinctly deal with civil and criminal litigation, which are two different beasts, both involving court. Civil litigation is where I sit. And then, the part of that question, Natalie, that you asked, when are you required to go to court? And again, what does going to court mean? It's such a long process. And I think most of us think about going to a trial, and certainly when a client contacts me for advice, I think a trial is the thing that they're most deeply worried about normally, whether they're claimant or defendant. Rarely people want to have their day in court, as it were, because a huge part of the advice we have to give is a discussion about the risks involved with either losing or having to have forked out for your lawyer and lose. So very long process culminating in actually going to court. But actually, if you said to me what's involved with going to court, I would say, well, a very long process starting with usually what we call pre-action correspondence, such as a letter of claim, a letter of response, and then perhaps a bit more back and forth sometimes before actually a claimant makes a decision to issue court proceedings, and then a long process timetabled by a court to get you ultimately to a trial.
Perfect. And what happens in court from a litigation perspective? So,
as I said before, the actually going to court is usually the end of the culmination of your dispute. And despite trials being, listed is the terminology we use, for trial for various lengths of time. Sometimes a day is enough, sometimes 5 days. Certainly from my point of view in civil litigation, unless the dispute was very basic, we would always use a barrister, simply because by that point, the sheer quantity of evidence that needs to be considered and the arguments that need to be put forward, and also the witnesses that need to be cross-examined, involves a skill that we solicitors learn the basics of, but certainly the barristers are, that's their job. That's what they're paid to do day in, day out. And actually, from a solicitor's point of view, it's interesting because you take more of a observational role when it comes to trial, and also a bit of hand-holding and reassuring and explaining things to the client sort of role. And it's the barrister's day to shine. And I guess, again, if we talk about the process leading up to that point and what happens, I mentioned in answer to the previous question that the court will give what we call directions, which is a timetable leading up to a trial. By this date, you must have witness statements from all your witnesses prepared, and you must exchange them with your opponent. And various things like that, bundle preparation, and the solicitor's really heavily involved and is conducting that aspect of trial preparation.
Perfect. So just a final question for you. When hiring barristers, what makes you want to choose like one person over another? What do you look for?
I think that's a really good question. And just to be sure, we don't have any barristers here on this call, do we?
Oh,
good.
No.
I don't think I will cause offence, but I choose my words carefully. Yeah, interestingly for me, I mean, so when you go onto a barrister's chambers website, you'll see that they have profiles and CVs. You know, they're selling their skills, their experience. So, you know, clearly it's really important to make sure you have got a barrister that actually specialises in the right area and knows their subject matter really well, and perhaps has some experience of similar cases so that you can be guided by them. That's really important, particularly because although, you know, it sort of comes across as though a barrister turns up on the day to represent you, actually in civil litigation particularly, they're involved regularly throughout the entire process, and sometimes it's advantageous to get your barrister on board early so that they can actually, you know, provide their input from an early time. But for me, those things are a given, that they've got the experience, etc., etc. But for me, the most important thing is personality. Often there's good choice in relation to availability and experience, but actually picking a person who you know is going to be right for you and what you understand of your case and also your client. You know, I've got some of my cases I would say are I can afford to, I've got a bit more wriggle room with them. I can be a bit more creative with them. And so I'll pick a creative, imaginative barrister. Other cases might be more complex and I need somebody with a really academic brain. But then, as I say, the client's important because you want to put them in a room together and know that they're going to bounce and communicate well. And I think sometimes if you've got a rough and ready client and then you end up picking a barrister who's an Einstein, might not work quite so well. So dynamics as important as anything in the decision making, you know, when it comes to who to pick.
Definitely, and I think I can add to that point in terms of the care and public department. Sometimes you've got those clients that are quite, they'll keep you on your toes, shall we say. So we do try and look for the most kind of robust barristers, what we might call the most quite forward, quite blunt, the ones that will tell you straight, yes, you've got a good chance, or you know what, no, but this is what I can do for you. So definitely.
And there's no wrong or right, really, is there? I guess yeah.
Perfect. Well, thank you, James. If anyone has any questions for James, you can message me directly in the chat or you can speak to Robina. So I'm just going to quickly talk to you now about a bit of work experience that you can do to kind of see whether or not going to court might be right for you. So if you attended my webinar last week, we touched briefly upon mini pupillages. Now, you might be aware a barrister in training does a pupillage, and it's where they go to court and they sit behind a barrister for 6 months and they learn from them and learn their traits and what they should and shouldn't be doing. And then the next 6 months, they are up and speaking in court and the barrister's observing them. So when you kind of do a mini pupillage, it's the same thing, but obviously we don't speak in court. And you just kind of sit and observe everything. Now, 2 years ago, I think it was now, I was on my way to an event evening in Leeds and I was completely lost in the middle of nowhere. I didn't know where I was, didn't know where I was going. And I just asked someone in general and just said, do you know where this is? And they were like, yep, that's absolutely fine. I can take you there. And I just kind of got talking to them and they were in a law firm. Now, at the time, I didn't realize that this person was a director of the law firm. And you know, he was talking to me about what I wanted to do, where I wanted to go, if it was a university, if it was an apprenticeship. And he, at the end of it, said, you know, here's my card. If you're interested in doing a mini pupillage, then let me know. So I think the first thing to take away from that is make sure when you're speaking to people out in public, you know, present yourself in the best way. I didn't know he was a director of a law firm, and I could quite easily have just kind of fobbed him off and just been like, oh yeah, thanks, bye. But I took the time and spoke to him, and he spoke to me. So that's one key point. And anyway, so I got to emailing him, and he said, look, you can either do a mini pupillage in Leeds, or you can do it in London. So I was like, I fancy a trip down to London, let's go down there. And I sat behind a very experienced criminal barrister in one of the Crown Courts. And it was an interesting case. It was about gangs, it was about drugs, it was about stabbing. So it's a great way for you to learn in the courtroom, and for you to see what a barrister does, for you to see what a judge does, and also for you to see what a jury does. They sit there, they have to listen and take all the evidence in. So they're really, really good. They really, really allow you to gain some experience and kind of see, actually, this might be something that I want to do in the future. So I know at the minute it's a bit harder because it's COVID, but I am aware that some barristers' chambers are still running mini pupillages. So it might be that you look on a barristers' chambers website, or if you simply type in mini pupillage near me on Google, there'll be a website that comes up and it lists barristers' chambers who do them, and it'll list, you know, kind of what area of law they do, because it might not just be criminal law that you can do the mini pupillage in. So if it is something you're seriously considering doing, about going down the route of being a barrister, or going down the route of being a solicitor but wanting to know what it's like in court, then definitely look one up. I did mine for a week. You can generally, a Crown Court case, depending on how long it is, will last 2 weeks. So, you know, if you can get the time off college, or if you do it in the summer holidays or something like that, then I definitely would recommend doing it. It's invaluable experience. It helped me learn a lot, and I'm not the most forward person when it comes to speaking in front of people, even though I'm doing a webinar today. So I think it kind of helped me realize maybe I would like to be behind the scenes a bit more, and actually dealing with the clients on a one-to-one basis and prepping the statements. So it is a good way for you to see what the life of a barrister is like. And if you're lucky, you might even be able to go into some client meetings, which I was able to do as well when I was there. So definitely have a look at them. I think, like, they're invaluable. I would definitely recommend them. So that's all I have really to say on mini pupillages. If anyone has any questions at all, then please send them in the chat, or if Rubina has anyone that would like to ask any questions, then Rubina, you can obviously raise your hand and just let us know. So I'll just give you a few minutes to do that.
Nothing from this side, Natalie. There might be something in the chat.
Let me just have a look. No, I can't see anything. So what I'll do then is I will end it there. If students obviously have any questions, they can email me directly. I'm absolutely happy to receive the emails, and I'll forward it on to the relevant person. And good luck to everyone in the future and in doing what you want to do. So thank you for the speakers as well in participating, and I'm sure I might be calling upon you again at some point in the future.
Thank you very much, everyone. Thank you for your time.
Perfect.
Bye, everyone.
Take care.
Thank you.
Bye. Thank you.